Good afternoon and welcome to today's webinar, Top 10 Legal Facts that Family Caregivers Need to Know but Probably Don't. My name is Juliana Valencia. I am the supervisor for the Caregiver and Supportive Services Unit with Fairfax Area Agency on Aging. Before I introduce today's speaker, I will go over a few housekeeping items. Today's presentation is being recorded, and a link for the recording will be sent to all registrants a week from today. We have enabled closed captioning in case you need it. And also there is a Q&A button where you can submit all your questions or concerns. We are going to allocate a few minutes at the end of the presentation to address all of them. There will be a brief survey as you signed out. If you could take a moment to fill out that survey, it truly helps us provide topics that are important to you. Also, if you want to share any comments or any concerns with our speaker today, please make sure you include that in your survey. Now, it is my pleasure to introduce today's speaker, Rory Clark. Rory is a native of Virginia with deep roots in his community. Rory has more than 30 years of experience practicing elder law, estate planning, asset protection, Medicaid planning, veterans affairs, and special needs planning. Through his personal journey, Rory not only understands the complex legal issues involved as a professional, but also the intense emotional issues as a caregiver. Since 2000, he has held an AV preeminent peer review rating by Martindale-Hubbell, meaning he is nationally recognized as a lawyer with the highest levels of skill and integrity and has reached the height of professional excellence. Rory has also earned an AVVO Superb rating 10 out of 10. Additionally, he is an accredited attorney for the preparation, presentation, and prosecution of claims for veterans and benefits before the Department of Veterans Affairs. He is admitted to practice in Virginia, Maryland, and DC. In 2019, Rory authored the Family Estate Planning and Elder Law Guide. Rory is sought after as a frequent public speaker on issues of elder law, special needs, and taxation. A longtime resident of Loudoun County, Rory was reappointed vice chairman of the Loudoun County Zoning Board of Appeals in 2020 after many years of serving on the board. A member of the National Association of Elder Law Attorneys, in 2021, Rory was elected to the board of directors for the Virginia Academy of Elder Law Attorneys, where he serves as chair of the Member Relations and Communications Committee. In 2022, Rory was designated as one of the 2 qualified master counselors in Virginia. Rory, welcome and thank you so much for being here. We are looking forward to your presentation. I know there is a big interest in this topic, so please take it away. I'm going to stop sharing now so you can share your screen with us.
No worse than it was. Okay. Well, the good news is I am not one of those presenters who puts a ton of text on the screen because I find that people get lost in it. And when they're trying to read it, they don't hear what I say. And I'm certainly not one of those presenters who just reads the words that are on the screen. So these are sort of mental notes to help follow what I'm going to say. So look at my balding head and my smiling face and listen to the words. That'll be the best part. So, and Juliana's done a great job. This is actually the 3rd time we've gone through trying to make sure that we were getting this out presented really well. So if there's a problem, I'm sure it's a technical problem on my end. The first question that I wanted to point out is when people are starting to look into this, they will sometimes see information that a person identifies themselves as an elder law attorney or an estate planning attorney. Some folks don't think that there's a difference or wonder if there's a difference, don't even know that there's an issue. Other people are very confused by it. And there's a reason for this. When I started practicing law in the 1980s, there was no such thing as an elder law attorney. We were all just estate planning attorneys. And amongst ourselves, we would say we really dealt with death. We were death planning attorneys. We helped people distribute their property the right way when they passed away, maybe spent time avoiding this thing called the probate process. We spent most of our time helping people minimize or avoid something called the federal estate tax. Well, that issue has become much, much smaller. Instead of being imposed on people who had merely $600,000, and in Northern Virginia, you could own a house, have a small insurance policy and a retirement plan, and you'd be over $600,000. Today, a married couple has to have way over $24 million to be subject to the estate tax. So that is not such a big issue anymore. Over the last 2 decades, that has declined. But something has happened in the last 2 decades differently. A new elephant has come into the room, and it's the long-term care elephant. And in response, the law industry has created a new specialty of lawyer called the elder law lawyer, who focuses on life planning for people with disabilities. They may be younger or they could be children, but they're mostly, most of our clients are seniors. We do help with those end-of-life issues, of course, but we're focused on helping people maintain dignity and independence during the last 2 or 3 decades of life before the end. And frankly, we're focused on making sure people have something left over to deal with at the end of their life. Because long-term care costs are so crazy high, many people are finding that they're becoming completely impoverished during the course of dealing with their long-term care issues. So here's the way to think of it. Every elder law attorney is an estate planning attorney, just like every cardiologist is a doctor, but not every doctor is a cardiologist. Not every estate planning lawyer is an elder law attorney. There are still plenty of lawyers around who do the traditional work of helping people focus on those end-of-life issues. But if you're concerned about life planning, care coordination, asset protection, and management of a long-term care plan, you want to be looking for a lawyer who holds him or her self out as an elder law attorney. Okay. The next point I wanted to point out is something that we see quite a bit, because we deal with folks who are in this transition and at the latter phases of their life, where they have gone from their private insurance, usually provided by an employer. They've moved on to Medicare. And of course, many of them are dealing with fixed budgets and incomes, and they're looking for ways to manage how they face their expenses. And they often do this at a time when they're in a relatively good position of comfort and physical health. And they look at these options that are available to them under the Medicare system. And there's a plan, it's actually a group of plans called Medicare Advantage. And the point that I want to make today is that many folks do not understand that Medicare Advantage plans are not created equal. Each one of them is an opportunity for you to explore what costs and what benefits are best for you. Let me give you a story that emphasizes how just making an assumption that they're all going to be acceptable could be to your disadvantage. We had a client a few years ago who was on a very modest income. He was starting to have bumps and grinds. And so he was seeing a number of doctors. And he said was killing him was his copays. He had 5 or 6 different doctors that he saw on a regular basis. None of them were for large, serious things like cancer, but he just needed to see doctors on a regular basis. And each and every time he went to see a doctor, he had to pay these copays. And someone told him about how he could get a Medicare Advantage plan that would give him no copays. Well, he thought this was wonderful. He looked into it and he found that at no additional cost, he could get coverage that would give him no copays. He made an assumption that every other element of his insurance package was going to be the same. And he said, well, of course, I'll take this choice. And he never looked at it again for 10 or 15 years. And then we got involved when his daughter came to us, and he was starting to have more functional limitations and some problems. And the point here was she came to us ready to scream. She herself was a person of very modest income, was desperate to take care of her father, and had found out that when he had gone into rehab after a hospital visit, when he had been diagnosed with a very serious healthcare issue, instead of getting a traditional 20 days in rehab, 100% paid by Medicare, and an additional 80 days paid at least partially by Medicare, he was only getting 7 days total in rehab. On the 8th day, Medicare paid nothing. Now, for 10 years, he was winning. He didn't pay a single copay, and he was very glad for his Advantage plan, but no one pointed out to him that what he was giving up in order to get that significant benefit was a limitation on his rehab. He never used it in those 10 years, but in the time that he needed it, it was incredible, because every single day in the rehab facility that he was having to pay out of pocket was well over $500 a day. And it was financially devastating for the family. So I want people to point out that when they see these commercials where you can have meals delivered to your house, and you can have these kinds of visits included, and home care and all these other things, those are all options. And in fact, there are options where you may even get some money back on your Social Security check. But what you need to remember is you don't get all of those things. You can pick and choose those things that are best for you, but you need to look at what the consequence is, what you're giving up in order to get that benefit. You can pay more and get more benefits, but it should just make logical sense that you're not likely to pay less or the same and get more benefits. You need to make sure you're looking at the balance. I'm not for or against any of those particular balances. I just want my clients to make sure that they look at that package that they're getting to make sure it fits them best. And remember that every year in open season, you can revisit that, okay? So don't set it and forget it. Look at it again every year to make sure that as you go through the continuum of life and your needs change, that you're making sure you've got the best fit possible with your Medicare insurance. All right, the next thing I want to point out is that I have some folks who come to us with a family member who has fallen into a need. They've lost the ability to manage their own affairs. They're not paying their own bills, or they're not able to pay their own bills. They may be of modest income and means, and these friends or family members are highly resistant to stepping in and help because they have heard that they become personally liable if they start signing checks for someone or take on the role of court-appointed conservator to handle affairs. And nothing could be further from the truth. A conservator is a court-appointed agent to help a person handle financial means. But the law actually makes it very clear. It's in the statute that anyone who becomes conservator is not ever personally liable simply because they have volunteered to take this role. It's their obligation to use their ward's money to pay their bills, but if there's not enough, we've got to find some other solution. The result is not that the conservator is legally or morally bound to pay for these persons' liabilities. And we have seen probably a couple of times a year, a family will come to us and say that the person who's best suited to help a person deal with financial matters, that is to say, sign the contract with the nursing home or the assisted living facility, or pay the bills, pay the mortgage, has refused to do so because they believe that they're putting themselves personally at financial or their own individual family personally at risk. You're only financially liable if you personally agree to pay something. If you personally say, I will pay out of my own money, then of course you're liable. But just because you're doing it for another person does not mean you're liable. Indicating your representative capacity or your agency capacity, or specifically that you are guardian, does the trick. So any of you watching this presentation today, if I were a court-appointed guardian for you, and of course you can imagine as a lawyer that happens to us a good bit, all I need to do when I sign anything of legal liability, whether it's a contract or a check, I sign my name, Rory Clark, comma, conservator, and simply putting that comma and the word conservator afterward makes it clear that I am not ever personally liable for that debt or that obligation or any other obligation of that person. I'm simply doing that person a favor. I'm acting to help them meet those financial needs. Okay, so not only is there not a legal or a moral implication, the truth is actually quite the opposite. There is no legal obligation. There is a release of liability for conservators as long as they're clear that they make sure and they make it clear that they're only acting in that capacity. All right, question number 4, a related issue, and this is one of very high importance just in the last few months. I was talking a minute ago about conservators. Conservators are appointed by the court to handle financial matters for a person. It could be a child, could be a young adult with Down syndrome, autism, disability, could be a senior who is going through dementia. It doesn't matter how we get there, but if a person needs help with their financial matters, the court can appoint someone to handle those financial matters, and we call that person a conservator. But what about personal decisions? Where will you live? Will a hospital procedure be done? Will an operation occur? Will medicines be given and taken and so on? Well, those issues, those personal issues, are handled by someone called a guardian. The guardian is appointed by a court on the same basis to handle these personal issues. Now, we can have an individual who has a guardian and no conservator. They can have a conservator and no guardian because people have different capacity issues. But often we see a person who needs help has both a conservator and a guardian, and very often it's the same person. On the financial end, the conservator does need to file with the court regular accountings to transparently report on what they've done with the assets and the income that they're controlling on behalf of that individual. On the personal side, however, there is also an obligation to report. And the law requires reports be filed with the court, and they're in open court. They're not under seal, and also with the Department of Social Services. These are publicly available records. Traditionally, the information there is what you would expect to see of anyone who is acting in a public capacity to protect someone, so that people could look into it and make sure that someone was acting within the scope of the law and doing what's in the best interest of the individual. Well, last year in 2022, the Virginia General Assembly passed an amendment to the statute on reporting for guardians that causing a major stir. There isn't any evidence that the General Assembly understood the consequence that I'm going to talk about today, but I'm telling you, in my practice, we're seeing this on a very regular basis. Out of a good intention, they have required that guardians, unless there is something different put in their order by the court, they must report publicly in an open file things like their personal view about the diagnosis of their ward, whether they're likely to improve, even if they're not a doctor, and they must disclose publicly every diagnosis that their ward has received. And as you can tell, even if you don't understand the law, these sound like real intrusion into a person's privacy. As a matter of fact, under federal law, each of us has privacy rights secured by a statute everybody knows as HIPAA. This is the thing that is so annoying when you go to the doctor's office. You can't just say, I'm here for my appointment. You've got to fill out all these forms saying who it's okay for them to share information with, including other healthcare providers or family members. I was recently at a doctor where they wanted to know whether they could leave me a voicemail message because somebody else might have access to my voicemail. So how can it be in a world that we have a federal law that secures people's privacy rights and makes sure that that private information is protected and not publicly disclosed, the Virginia General Assembly can actually not just simply request, but require guardians to disclose this same information and not put it under seal in a court file, but literally file it in the public records at the Department of Social Services or in the public file at the courthouse. We think this is a problem that is going to come back to the attention of the General Assembly and that they're going to have to address this. Because what's going to happen is that we're going to find that guardians, when they get to that annual time and they have to file the report, the first time they see this, many of them are going to become very, very upset. Some will not think they have a choice, and they will disclose that private information to the disadvantage of their ward. Some may do it under duress and stress. Others are going to seek some relief. But the problem is, it's a very difficult thing to get a judge to declare a statute unconstitutional. And that's where this is headed. If the General Assembly doesn't solve this problem, or if you don't solve this problem with your lawyer, eventually some judge is going to have to say there's a conflict between the Virginia law and the federal law and strike down this statute. And as I'm telling you, judges are very, very hesitant to do it. Here's what you need to know. You don't have to be the test case for this. I want to tell you about a case we had recently. A mother of a 32-year-old son with paranoid schizophrenia as a central diagnosis, lots of other things that, and he is aware and engaged. He lives in a group home, but he is, because of the paranoid schizophrenia, very, very concerned about who knows about him, things about him, where he lives, his condition, his finances, all of those kinds of things. And if he were to think that important, vital information about him was publicly available, it would in and of itself be very disrupting to him. And his mother was totally unwilling to be put in a position where she would be forced to violate his rights. Good news is there was a solution. We went to court, got the judge to amend her guardianship order, and we specifically addressed this issue. In that particular case, we got the judge to recognize that the ward maintained capacity to exercise his privacy rights, and we excluded the obligation to report on a number of important issues, including these privacy issues under the new statute, from the guardian's obligation to report. So she is now no longer going to be required to do it. We've done this 4 or 5 times for clients. Each one of them who has become aware of the issue is very, very glad that we brought it to their attention. But I am telling you, there are thousands and thousands of people in the Commonwealth of Virginia who are acting as guardians for loved ones who have no idea that when they get to their next annual report, they're going to be confronted with this issue. So if you are, in fact, a legal guardian for a ward right now, and you haven't done your 2023 annual report, you may want to reach out to counsel about having your order amended so that you can avoid having this legal requirement to violate your ward's privacy rights. Okay. Let's go on to the next important fact that people need to know. We can avoid guardianships and conservatorships if we do private planning. We just need to do it at a time when the person whose affairs, personal or financial affairs we're dealing with, has the capacity to name someone to privately manage those affairs for them. We don't like to do guardianships and conservatorships because they cost money and they take time, and they do involve public disclosures, even if those disclosures are minimal or justifiable in our system. But we can avoid that if we give a healthcare power of attorney, or we give advanced medical directives in advance, privately telling our caregivers how we want issues to be handled. And we can name a person to act for us under a durable general power of attorney to handle financial affairs for us And none of that requires accountings filed with the court or these public disclosures to the Department of Social Services or in court files. It can all be managed on a private basis and be kept within the family. So remember, the guardianship and the conservatorship are really emergency measures when we have no other choice, but it is far less expensive, far less intrusive, and far more flexible for people to be able to appoint individuals on their own to handle these financial and personal matters. The two important tools that I want to make sure people are aware of when we are dealing with the end of life, I want to make sure people are aware of the difference between a last will and testament and something called a revocable living trust. These are both very common tools in America for people to handle end of life affairs, but they are very, very different and distinct. And so I want to make sure people understand the difference between those. Last wills and testaments have been legal in the English American system for about 400 years. They have no applicability during your lifetime. The law says they literally speak as of your death, and they are only controlling about your personal wishes. Who do you want to handle your affairs? How do you want your affairs handled? And how do you want your property distributed? And that is all applied after your death. This way of handling your affairs, however, because it was designed so long ago, when most people in English society were illiterate, the law required if you wanted to make a will, you needed to permit public review and accountability for what was done to make sure that widows and orphans were not taken advantage of. So a consequence of doing a last will and testament is almost certainly there is going to be something called a probate administration of your affairs. People have done it for hundreds of years, but it is public. Everything that you own, every distribution that you make is put in public record, that anyone who seeks those records is entitled to go to the courthouse, open the file, or go to the Commissioner of Accounts office and see those records. In a society where most of us are not illiterate, and we do have people who can manage our affairs for us, see the value in using something called a revocable living trust. It very simply avoids the need to go through the probate process, and it simply says the assets that I put in this trust during my lifetime, after my death, here's what I want the trustee to do. We name who's in charge. We deal with the issues that need to be addressed. We distribute the property to the people that need to be, they need to receive the property. And all of that is done without the need or requirement of paying a probate tax, going to see the probate clerk and qualifying, paying bonds, and publicly disclosing the activity under the, and the list of assets of the person who died. Maybe most important consequence of this, let me give you a summary or a story from my own life. It's very unusual for us to be able to wrap up the administration of a probate estate in less than a year. It is sometimes takes more than 2 years, depending on the complexity of the person's affairs. In contrast to that, an administration of a trust when someone dies can go quite quickly. My mother had a revocable living trust when she died. She died on a Wednesday. I was her successor trustee. I immediately dove in to take care of her affairs. I was finished with the administration of her affairs the next Thursday, 8 days later. That's the kind of a difference and kind of a gift you can be making to your family if you don't use the old-fashioned simple will and you simply put in place a revocable living trust. There are other benefits to a revocable living trust as well, but the probate avoidance, the avoidance of the probate tax, the costs and the accountings and the privacy improvement is just amazing. Fact number 7, I want to tell you that this is the first of 2 benefits that are available to people to deal with long-term care costs. And many people do not know that these benefits are available to them. The first one is that I want to talk about is called VA, Veterans Affairs, Aid and Attendance. And it is a long-term care assistance available as a thank you, kind of like the GI Bill, for wartime veterans and their surviving spouses. What's wonderful about this is that it can be paid to people who have significant assets as long as they've done appropriate planning. The benefit is from about $1,400 to $1,500 a month for a surviving spouse, to $3,500 a month if I've got 2 veterans married together who both have a need. And the money that is paid under this program is tax-free. So for many people who have served the country or surviving spouses of people who served the country during a period of wartime, this is just enough extra cash, tax-free, to, in addition to their regular income, meet the expenses of, say, an assisted living facility or having care come at home without having to do a deep dive into life savings. There are 3 eligibility criteria. Generally, for people who are now looking for services, the rule is, did the veteran serve 90 days on active duty, 1 day during a period of wartime, and was the vet not dishonorably discharged? When it comes to surviving spouses, we need to be able to prove that they were married for at least 1 year before the veteran passed away. Medical eligibility is met when the person's doctor, not a VA doctor, their private doctor, is able to document or states on a form that the individual is 65 years of age and need help to be safe. It's a very, very loose definition. This is not a benefit for people who are not getting care. If you're paying for care, the benefit kicks in when you spend more on a monthly basis than you make in your regular monthly income. The purpose of the program is actually to make sure that you have that aid to make sure you keep your food and the roof over your head, and so you can have that attending assistance at home. So if you're incurring expenses for care that are unreimbursed, that's the time to look at this benefit. And it's available to you if you have less than $150,000 approximately of assets that are countable. And when I do countable and I do the quote things with my finger, that means we don't include in that the value of a private residence or what used to be a private residence owned by the vet or the surviving spouse. Vehicles aren't included, and any amount that's been previously moved to an asset protection trust prepared by an elder law attorney, those dollars, an unlimited amount, you could have millions of dollars in that sheltering trust. As long as there's only $150,000 or less left outside of the personal residence or the trust, a person can seek eligibility under this program, and the money is wired straight into the account. I got this for my dad, who was a World War II veteran. It's really very useful and helpful. The second one I want to tell you about is that everybody who is an American citizen or is a legal resident and has eligibility for Medicare and Social Security is entitled to take advantage of an unlimited long-term care program called ABD Medicaid. This is an important thing to know because the costs of care are becoming so high that 50% of couples in America and 70% of individuals are impoverished within 1 year when they have a long-term care need. ABD is not a welfare program. People pay for it out of payroll deductions, just like they paid for their Social Security and their Medicare. And those 3 programs together, Social Security for income, Medicare for health insurance, and ABD Medicaid for long-term care insurance, create a stable stool for our seniors to be safe in their senior years. The benefit is unlimited in terms of dollar amount. That is to say, you could be in a facility. It doesn't matter what the private pay rate is. If they are in the Medicaid program, they will accept the payment from Virginia Medicaid and provide care. If you need it for 5 years, 10 years, 20 years, 60 years, it doesn't matter. The benefit is unlimited. We find it most useful in our office because 75% of the people who use this benefit use the money to pay for caregivers to come into their own homes. I have never had a client come to me and say, Rory, can you help me go to a nursing home? My clients hire me because they never want to go to a nursing home. They want to age in place. And this program is a very, very useful tool for paying for private caregivers to come into home and help people live with dignity and independence in their own homes. Quickly, I just wanted to give you an example, because if you're going, wow, this can't apply to me, this is, I've changed the names to protect the innocent, but this is a situation for a family that we dealt with recently. The man in the couple had a stroke, literally in the field. He was a farmer, needed nursing home care. It was clear that he was not going to be able to come home. At the time that happened, they had a family farm worth almost $4 million. They had a beach house in North Carolina. They had investments of almost $150,000. Jean had antiques and some nice pieces of jewelry. And Jean was very much concerned about being in control of their family affairs. A skilled overall attorney can shelter those assets and make sure, as we did, that Bob was able to secure his ABD benefit. As a matter of fact, Jean paid nothing for any of Bob's long-term care. He's at a facility that she chose, and she has been able to keep in the family, the farm, the beach house, or virtually all of their family wealth that they didn't pay for the lawyer to help connect them to the benefit. And no one even suggested that she needed to sell any jewelries or antiques. And today, even though he is in nursing home care, she has 100% control of the farm, all the activities on the farm, that beach house, the investments, and of course, all her personal property. The last two facts I want to wrap up here in the last couple of minutes talk about this continuum of care, or this path that we get on as we get later in life. And a point one I want to make is that there is very often an assumption made by people that as I have an increasing need for care, or my functional limitations increase, the cost of my care is likely to increase, and that if my environments to live are home, say a 55 and over community, assisted living, memory care, and nursing home, there's a direct correlation with expenses as I move from home towards the nursing home. And that is actually not the case. In fact, it turns out that the most expensive care is actually back at home. If we pay, if you had a great rate, $27 an hour, and we know people paying as much as $45 an hour, if you paid $27 an hour for 24 hours of care, that's well over $20,000 a month, well over $200,000 a year. And that's very unusual for a nursing home to become that expensive. And I'm sure you imagine that assisted living facilities, of course, are not that expensive either. Another consequence of keeping care at home is that there tends to be an overwhelm that hits family caregivers. And as a consequence of that, that creates a strain not only on the person who needs help, but on family members as well. Quickly, this is the sequences that we just need people to sort of keep in mind. Everybody sort of knows this generally, but this sort of helps you visualize that when it comes to health and functional limitations, there's sort of a progression when we go from normal activity, say in youth or middle age, to limited functionality down to significant functionalities before we die. This is that continuum that I was talking about. A home, living independently in your home. Maybe we have assistants come into the home, retirement community, assisted living, memory care, and nursing home. Money. We don't spend anything on care. Maybe we spend a little, we spend more, we hire people to provide care for us, or we pay for a facility. Finally, many people get to a point where they have no money left. Disconnected from all of those are benefits. Of course, people have private funding. We've talked about VA funding. There's community services helped with access by wonderful people like Juliana to help us, connect to those benefits. We have Social Security. Of course, we've got family members, and we've got Medicare and Medicaid that I've talked about today. Here's the point. These things are not in lockstep along the way, and it pays when we start going down one of these paths to think about how they relate together so that we can bring benefits, for example, at a high end, like say Medicare or Medicaid, apply them at home where costs can be most expensive and allow people to stay in the living environment that they like, because everybody prefers that maximum dignity and independence. That is why firms like ours have added companies like Guidewise to their legal services to provide a holistic approach, because lawyers are not typically very skilled at things like paying bills or doing care oversight or care coordination. We're really good at writing trusts, writing powers of attorney, and those kinds of things. And looking for a practice that has a holistic approach or multidisciplinary approach so that you can find some help to get the bills paid, get access to the benefits, have the legal tools brought on board, and have the care coordinated and have it all managed in one place makes this much more stable for the person who needs help, and really, really cuts the stress and the pressure for the family caregivers. And 10 years ago, you really didn't see these multidisciplinary practices or multidisciplinary approaches. Look for words like care coordination or life care planning, or ask the elder law lawyer that you're talking to. Remember, an elder law lawyer, not an estate planning lawyer. How do they work, or do they have a service that offers the care coordination and the healthcare approach so that this can be done efficiently, inexpensively, and relieve as much stress on the family as possible? Okay, so I'm already a few minutes late. I was going to share really fast, Juliana, some things. You actually hit all of these things on the qualifications for our firm. I was going to tell people that I'm passionate about this because my own family journey, but you also mentioned that, Juliana. This is my mom who had Parkinson's for 14 years. This is my dad who had Alzheimer's for 11. I've got two children, two sons, each with special needs. My 28-year-old has autism. My 25-year-old on the right, who is an opera singer, is already blind in one eye because of an autoimmune disorder. This is my family mess or whatever, but I also have great strengths and great assets in my family, and finding a way to balance those strengths against the challenges and bring on board the legal tools is what provides success. So 3.5 minutes late, Juliana, but I promise I'll be willing to stay late if anybody has questions. I know you're going to collect those and curate them, but I'll stay as long as people have questions.
Oh, thank you so much, Rory. That's not a problem. I so appreciate your presentation, and I think it was so informative. And at this point, I want to invite everyone in the audience to submit your questions. There are a few already, so let's begin. So the first question that we have, it says, do IRAs go into trust or to spouse as beneficiary and then into deceased spouse's trust or into trust on first spouse's death? Ooh, did you get that?
I did, and what I thought I would do is, so that I wouldn't distract people, was that I would stop sharing the presentation and people could see our charming faces a little better. The answer to that question is actually quite straightforward. It is one of those issues where we're talking about something and there's really some deeper issues down below. There is no way to have a retirement account in a trust. It's against the law because IRAs, SEP IRAs, KIOs, thrift savings plans, 401ks, 403bs, all of these are what we call qualified retirement accounts. And we have them and we get them out of a deal with the government that if, as long as we put our money into these investment accounts, we will be allowed to let them grow on a tax-deferred basis. But the deal the government gets is eventually they will get their tax dollars. And the reason it's illegal to put them in a trust is trusts don't ever reach the age of 72. They're not human beings. Retirement plans must be owned by real, living, breathing human beings, so the IRS knows when to get their taxes. So what we do is we deal with the money that comes out of retirement accounts, and we mainly manage those through trusts, but we never put ownership of the retirement accounts in trusts because it causes them to be taxable immediately, and that's usually an outcome nobody wants.
Very important to know. The next question is asset protection and irrevocable trust. That's
not a question. Oh, is it? Is it?
Yeah.
Yeah. So here's the best way to answer that question. The direct answer is yes, but that's not a very helpful answer because all trusts there's only two kinds. There's revocable, that is trusts that can be instantaneously revoked, and irrevocable are trusts that cannot be instantaneously revoked. Many people make assumptions that every trust in the category of irrevocable has the same characteristics. The kinds of trusts that we use to protect very wealthy individuals who are involved in litigation and so on, yes, those are what we call lockdown trusts. They are irrevocable, and nobody's getting those open with a crowbar or a judge or anything. The kinds of trusts that we use to protect assets for long-term care purposes, while they do meet the definition of technically irrevocable by the person who created them on an immediate and instantaneous basis, can still be amended. The beneficiaries can be changed. They can be terminated, and all the assets can be taken out of the trust and given back to the grantor. And all of these things can be done on an ongoing basis. We just use other tools that we're not concerned about, that we would be concerned about if we were being pursued by the mafia or the IRS. But if we're simply looking to get long-term care benefits in place, we don't have to go to that higher level. And here's the main reason. When I use a trust to help someone get their ABD Medicaid benefit or their VA aid and attendance benefit, we're not depriving those nursing homes or caregivers of money. We're just simply diverting them to a different source of money. Nobody gets nothing. The nursing home doesn't get nothing. The nursing home gets a considerable amount of money. They just get it from a different payee. So I know that's a little bit of a waffly answer. Technically, the person who creates an asset protection trust for long-term care purposes cannot personally and directly and immediately revoke the trust. But we do have indirect means to terminate the trust, amend the trust, change the beneficiaries, change the trustees. All of those things can be done. And for most of my clients, those are the important things that they need that are actually characteristics of a traditional revocable living trust. They're willing to accept the indirect means to get that outcome because they get the benefit of the long-term care assets.
Wow. So the next question, how do we keep durable power of attorneys from being changed, especially as we age?
Great question. So the only person who can change a durable power of attorney is the person who grants it. And the capacity to create a power of attorney is the same level of capacity to revoke it. If we have an individual, was just engaged yesterday on a case where my client granted a power of attorney to a child several years ago, felt she was pressured into it, that she didn't have a choice, and has now found that her home has been sold. She was moved 2 weeks ago to an assisted living facility without her agreement, and she wishes to cancel that power of attorney and get her house back, and get the money back from the child who sold it. And our suspicion is that she's stolen the money. So these are important issues, but the power belongs to the principal. And if the principal wants to change, they have the right to change if they have capacity. And so quickly, we have to talk about capacity. Capacity is a sliding scale. The capacity to understand that a spouse is trusted to handle your financial affairs for you means you need to know who you are, you need to know who your spouse is or who you're trusting, that you understand the consequences of giving someone authority to manage your affairs, even if you're not supervising this. And that's about it. It is not the same as the capacity to understand how to put a man on the moon, or to understand particular investments, like, say, for example, real estate investment trusts. It's a relatively low power, but it does mean that you understand both the benefits that come from granting a power of attorney and the consequences, the risks that come from granting it. When you revoke one, it's the same standard. Do I understand who I am? Do I understand who I gave the power to, and why it's important that I take it back? You need to understand powers of attorney in the context of conservatorships. When a person has lost capacity to handle their affairs, or if a person is abusing a power of attorney and exploiting an individual under it, this is where the court can come in. And when they appoint a conservatorship, the first thing they do is nullify all the powers of attorney so that everything is done under public supervision. So I'm not sure exactly what the nature of the question is, but if the question is, can somebody change my power of attorney for me? The answer is no. Only the principal can change it. If your concern is, mom granted a power of attorney and now she's getting a little shaky and she's saying she wants to change it and she wants to name her caregiver or her next door neighbor instead of me. Well, then if we're concerned about somebody exploiting that individual and getting them to change their power of attorney, that's where we may need to go to court and suggest to the judge that this person doesn't have capacity to revoke the old power of attorney or amend the power of attorney or to grant a new one to another person. So it all comes down to the capacity of the principal. And I have seen more than one judge say, in America, you have the right to be foolish with your own money. As long as you meet the level of capacity, you're entitled to do with your stuff what you want to do with your stuff. We're not going to stick our nose into their affairs. But when it's clear that people are being taken advantage of, undue influence, duress, fear, these things are at play, the court can come in and protect people.
Very important. Thank you. So the next question says, does my name on my father's bank checking account allows me to write checks for him if necessary, make me personally responsible for his debts?
That's a very great question. And that's one of the ones that touches on, I'm worried about helping. Okay. So let's talk about co-ownership. The presumption is that when two names are on a bank account, that those two people own that account 50-50. In my area of practice, I find that many times the child or the other person is on the account solely for convenience. because they didn't want to pay a lawyer to get a power of attorney to give to the bank so that the other person could sign the checks. Okay. We call it poor man's estate planning. You can rebut the presumption that accounts are jointly owned. And we have seen situations where someone has died and the kid on the account says, oh, all that money's mine. That $200,000 in that bank account is mine. Mom wanted me to have it. And it's not going into the estate and divided amongst the 4 different kids. So it's important that you think about these things because they do have implications. Here's what I would say about liability. If you are on an account with a parent or a friend, so that you can help them with their affairs, and you sign checks to become involved in that financial relationship, you're not designating your capacity, are you? Remember, I said it's important to say Rory Clark, comma, conservator, or Rory Clark, comma, attorney in fact. Getting the power of attorney, using it, and signing the checks with that agency affiliation makes it clear to the other party that you're only assisting your friend or your dad. But if you insert yourself in a contractual relationship and you sign checks, whether it's a written contract or an oral contract, there is some possibility that the other side may say, listen, my deal's been with you. You've been paying me for 4 months. And dad 2 years ago signed a contract for 5 years of service, right? And you have suggested that you're a part of the deal. I'm going to take your word, the fact that you've signed the checks, as an indication that you're actually personally responsible. We don't see a lot of it, but it is possible. The safest thing to do is to actually get the guardianship or the power of attorney and always indicate your capacity as an agent, as an attorney in fact, or as a conservator in doing the help. That way there's no question.
Got it. That's important. The next question is related to it. It says, what are the pros and especially cons of making accounts joint for an aging parent and daughter?
Well, I'll try not to repeat everything again, but we hit many of those same issues here. Yes. Why is it a joint account is really the fundamental question, because that's not typically documented. Is it because of convenience to help mom or dad pay bills, or is it because you really want to make a gift of it to that person? Can the child take the money while mom and dad is alive? Can they take half of it? Can they take all of it? The nice thing about the power of attorney is it's in writing and it makes it very clear what the limits of the power are and what the purpose of the relationship is. And with everything in life where there isn't clarity and it's not written down, we lawyers say this a lot, if it's not written down, it doesn't exist. If you just have a signature card down at the bank, when dad loses capacity, is not able to explain his intentions anymore, or if dad dies and there is a bad relationship between siblings, people can construe that vague relationship and they will construe that vague relationship in the way that's to their advantage. So if dad really intends for you to have the money in that account when they die because you're the one helping and that's a little extra for you, for God's sake, write it down. Why do you want to have bad blood with family members who think you're stealing from dad or stealing from them? On the other hand, if you don't want to be involved in someone's personal affairs other than just helping them pay bills, you're helping them, but you're not becoming personally responsible. Why wouldn't you go through the mechanism of getting the power of attorney or using a trust or using a conservatorship so that you make sure you know what your role is, and then everybody knows just by the definition of the role what the rules are and what you're liable for and what you're not liable for. That's a good recap.
So the next question says, does a power of attorney healthcare directive have to be redone or amended each time an older adult changes estates or if they share time between 2 estates? Does the attorney that sets it up need to be in the state you live in?
Another great question. So first point is an advanced medical directive and a healthcare power of attorney are two different things. The advanced medical directive is the individual's personal statement of what they want done with their care. A great example is if my illness is terminal and my death is imminent, do not ask my family what they want done. I'm telling you, keep me comfortable and let me pass. The healthcare power of attorney would be if I'm unable to communicate my intentions and the doctors need to do something, say, for example, operate on a kidney, I name my friend Joe to be the person to make those decisions for me. So there's a difference between those two documents. There is also the potential for difference from state to state. When I started practicing law, living wills or advanced medical directives were not recognized in Louisiana. Different states have different requirements about whether there need to be witnesses, whether the witnesses can be family members, and they have to be disinterested people. So if you move from state to state, it is a good idea to have a local attorney who knows the law in that state to review it. Generally, however, this is not a reason to discount that advice I just gave. Generally speaking, the law in the United States is becoming more consistent so that when people travel for vacations and so on, the wishes that they've expressed in Virginia are still going to be, observed in Florida. So there is a trend that is making this better, but the answer to your question is absolutely you should have them looked at again and again. I also should state that it is a good idea to have them reviewed every few years and re-signed, even if you don't make a change, just so that it's clear that your intentions are relatively recently expressed, because we have seen some cases, particularly on financial powers of attorney, where the age of the document has tended to raise a question as to, is this really what Mr. Jones wanted? We know it's what he wanted in 2002, but that's been 20 years ago. Has there been a change? Is there any reason to believe that this isn't valid anymore? So the best practice is every 3 to 5 years, even if you don't move from one state to another, to readdress that document, refresh it and sign it. Usually there are changes, addresses, naming of people that you'd want to help. And absolutely my advice would be if you move across a state line permanently, you should have a lawyer in the new state review it to make sure that it's absolutely enforceable in that state. You shouldn't panic about it. Don't lose sleep. The laws are becoming uniform, but it is a good idea to have them revisited when you move to another state.
Thank you. So we are past the hour, Rory. So if you are okay with us going a few more minutes.
You bet.
Perfect. So the next question says, we have a public guardian client who has an excess of Social Security income, funds over 13,000 that we need to address. Can you give guidance on whether we, the public guardian agency, can establish the trust for him?
So there are two kinds of trusts that are very useful in managing flows of money that are coming to individuals. And they can be really critical in helping to preserve benefits, not only from a Social Security standpoint, but also from a Medicaid healthcare, health insurance, and long-term care insurance. The answer to your question is the lawyer needs to look specifically at the nature of the stream of the asset or the income that's coming to the person. What should be the worst possible scenario is something called a first person or a D4A trust, where the individual who's receiving the money contributes the asset into a specialized trust. What this means is that the money comes into the trust. It's not treated as the income of the individual, which would threaten benefits, whether either Social Security, disability, or Medicaid. The downside or the disadvantage is that if there is anything left in that trust when the individual dies, it's subject to a state recovery. That is to say, the state can recover from the proceeds that are in the trust. If we're talking about a relatively modest amount of money, particularly money that is regularly consumed, it's terrible to see someone lose a very modest disability benefit, and they are simply living lower below the break-even, point. So we don't have a lot of anxiety about creating D4A trusts for folks who are going to use that money on a regular basis. But most of the time we're willing to do it if it means we're going to preserve benefits, even if there is some estate recovery at the end of the line. We do like to make sure that the people who are handling that money know that those trusts can be used for other things to support the individual, like education or televisions or computers or things to help improve quality of life. So I hope that's not too vague an answer. I think the specific answer is one should always be looking at a trust if there is an asset or an income stream that threatens a person's Social Security, disability, or Medicare, Medicaid benefits, because there is probably a solution. There may be some consequences to the solution, but usually those consequences are far better than the loss of the benefit.
Thank you. So basically you have to outweigh what's the biggest benefit for this person, right?
That's correct. Yeah, that's right.
Yeah. So
well, and family, members, right? So for example, we prefer to create what we call third-party trusts, because that means if mom or dad or an outside party creates, or the court creates the trust for the individual, it's not subject to estate recovery, and money that comes in from the family, maybe from uncles and aunts and grandparents and so on, if that person passes away, that money could stay in the family and go to other people who may themselves be disabled. But the problem is we have to voluntarily, on the first party trust, on the D4A trust, we have to voluntarily subject ourselves to this payback provision in order to preserve the benefits. If we're to that point where we're about to lose the benefits, it's almost always makes sense to do it. The real question is there a better way? Is there a way to do it without the payback provision?
Got it. Thank you. So the next question says, when we discovered that one of our loved ones was diagnosed with a terminal condition, what is the first step that we need to legally take, I guess?
Oh, wow. Well, I'm not trying to be silly, but birth is terminal. We're all going to die. Even Jesus died. So I would need more information to give you better guidance. If it's an early diagnosis of Alzheimer's and it runs 11 years like my father, well, we're looking at an issue of how are we going to pay for this continuum of care that could go on for 8 or 10 years. And that means we need to be focusing on dignity, independence, life, maintaining a living environment, and bringing resources on board. If it's a cancer diagnosis, pancreatic cancer, and the doctor has said we're already getting close, we're looking at 6 to 8 weeks, then we're not so much concerned about managing a decline in physical or physical ability, and how are we going to pay for long-term care. That's not really an issue. What we want to do is we make sure we've got that person's affairs in order, and that their liabilities have been taken care of, and that we've got maybe we have time to avoid the probate process at death and get a trust in place so that we can manage the transfer of wealth to the next generation. It may be, first thing I always ask in a situation like that is, has the client given an advance medical directive and a healthcare power of attorney? We can figure out the money sooner or later, the probate clerk or a judge or somebody, but the most important thing is, how are we going to take care of this person if the terminal illness is going to raise a question of whether or not they're going to be able to personally make decisions about the progress of their care. So tends to be that we look to get the powers of attorney, the advanced medical directives, and the healthcare powers of attorney on board first, so that we at least have another person who can help us do the next stage of planning, whether that's estate planning to deal with a potential death, or whether that's asset protection planning or benefit planning to deal with this continuum of care. But usually the power of attorney, the advanced medical directive, and the healthcare power of attorney are the long poles in the tent, the critical thing, because with those in place, we can often do the rest of the planning. And if we don't have them, it's going to become very difficult or expensive to do other planning.
Thank you. And there was another question here that I thought was interesting. And it's also related to power of attorneys. It says, is it better to have an adult child or your spouse as your power of attorney, or both? That's kind of a tricky one.
No, that's right. And actually the question is very well framed. And I don't know if the person who wrote this question had this particular fact pattern in mind, but let me tell you why we get that question a lot, because it's a blended family. Dad has two adult children from a previous marriage. He has maybe even a prenuptial agreement with his new wife. He loves her, he trusts her, they've been together for 20 years. But their deal is that when he dies, the money is going to go to the kids from the first marriage, and wife is going to get an insurance policy, right? So kids may say, gee, who's the one who's really in interest here? Or are we, who's the one who's best able to make sure the mortgage on dad's house gets paid? Well, that's probably the spouse who's living in the house. But if the purpose is managing the money for the investments for the next generation and the grandkids, that could be the children. Some people will say, can I name them both? Sure, you can. But that means they're both in charge at the same time. And you run into a silly situation where wife may be calling the financial advisor saying, oh my Lord, I just discovered that my husband was invested in Apple. Sell all the Apple and buy Microsoft. And then the next day, the son from the previous marriage calls and says, oh my God, I can't believe she's bought Microsoft. What a foolish thing. Sell all the Microsoft and buy Apple. And of course, we see this, churning and confusion. So the issues here are, the answer always depends on the desire of the principal and as interpreted through the lens of the family situation. You've absolutely identified the issue. Sometimes the spouse is the best person, but if the spouse has got Alzheimer's, probably not a good choice. Or if the spouse has a physical limitation, maybe not a good choice. If there's a blended family, we may want to have one power of attorney for some assets and a different power of attorney for other assets. Sometimes we want to have a spouse with a kid as a backup. We call those consecutive powers of attorney. Sometimes we want to have people, because they get along well and they can work together, we want to have what are called concurrent powers of attorney, where there's a personal understanding that if mom is able to get it done, she's going to act, but we're not going to force her to resign. If son needs to handle something in an emergency, we can have them both exist at the same time. So consecutive or concurrent, and who you name, these are the most important questions in creating a power of attorney. And I'm just sorry to tell you, there is no flat answer. It depends on your family situation, your desires, who do you trust with what thing that needs to be managed, and the answer might be all of the above.
All right. Well, two more questions.
Sure.
The next question, it says, if power of attorney becomes deceased before the principal, and now the principal doesn't have same capacity, are they then forced to have a conservatorship and not name a living power of attorney?
So let me restate that to make sure I understood it. And I'm going to use legal terms that I'm not trying to confuse, but to make it clear. So principal, the person who created the power of attorney named an agent who's going to act as attorney in fact. And in this particular case, the agent, or the person who is the attorney in fact, passes away before the principal, leaving no one with a power of attorney. But by this time, the principal has lost capacity because of age, illness, maybe dementia. Is there any alternative to seeking conservatorship to handle financial affairs for that person? I think the general answer within the scope of the question as stated is no, that's pretty much the standard situation when we get to a conservatorship. The broader answer is it might not be necessary if we have in place already a trust. Say, for example, the principal, in addition to a power of attorney, had granted or created a revocable living trust, where there is a mechanism for someone else, maybe even a judge, to appoint a successor trustee to handle affairs. Well, if we have all the assets in the trust, then I don't need to have a personal power of attorney. So the point that I'm trying to make here is that powers of attorney only relate to assets, contracts, legal rights in the individual name of the principal. But a person has a right to put control of those assets in things like corporations, or in my world, in trusts. So what we hope happens is that a person has used a power of attorney only as an emergency backup document. What we've always been intending is to have the affairs managed under a trust arrangement, which has built in all kinds of flexibility. If we lose our agent under the power of attorney, the first thing we do is look and see, do we have everything in the trust, or do we have individual assets? And if we find out we've gotten everything in the trust, then we're good. We don't care. But if we find out that we never created a trust, or we don't have all of the assets in the trust, that's when we've got to consider going to court. So this is a little bit of a depends on the situation kind of a thing. I love to give definitive answers, but it's pretty hard to do that in a generic question.
Yeah. So our last question, does having a healthcare power of attorney allow access to the patient's medical and mental health records under HIPAA?
That's a great question. So the technical answer to your question is it depends what the power of attorney says, the healthcare power of attorney says. Mine absolutely gives power. That's one of the main reasons we want to have the healthcare power of attorney, because we're aware of HIPAA laws, the requirements, and we know that waivers are going to need to be made so that we can get access to records in order to make quality healthcare decisions. But that doesn't mean the person who wrote that question meets that answer. I don't know if they went online and got it off of some form service, or they, made it up and wrote it out on on a cocktail napkin. There is nothing in the law that says Juliana can't write on a piece of paper, I name my friend Rory Clark to make healthcare decisions for me in the event that I'm incapable of making those decisions myself. And you sign it and we get a couple witnesses on there, that's going to be valid. But that doesn't say HIPAA, does it? Right?
Yeah.
So we have to read the document and we have to see what's in it. So this is why it's important you wouldn't do a root canal on yourself. You would go to a dentist. You shouldn't practice law on yourself either. You should make sure you've got a qualified person preparing a document that's actually going to address not only the question that you have in the front of your mind, but the things that you didn't think of. That's where people usually get caught. So I have seen documents that were created either a long time ago or in other jurisdictions or by people in good intention doing it on their own, where they just missed that issue and their agent had an almost impossible time effectively providing care because they had no right to get access to the healthcare information. They had to make decisions in the blind.
Yeah, very important to keep up with that language, that terminology, making sure it's included. Thank you so much, Rory. This has been such a wonderful presentation, and we can be here for hours, but I know you're busy. And I am so thankful that you have you were willing to answer most of our questions, and you share your knowledge and your time and your personal story of being a caregiver. Thank you so much. I really appreciate this presentation.
It was my pleasure, and I'm sorry for anybody who saw it sideways, but we can make sure we get it straight so that by the time you make the recording available, or if people want to call us, we can make copies available to people. So if people do have questions, they're free to contact the Legacy Elder Law Center, and we'll be glad to follow up with them. Thank you for inviting me. It's been a real pleasure, as always. Thank you,
Rory. And to everyone in the audience, I want to thank you for being with us. We appreciate your time. We know you're busy people, and yet you're here. So if you could take a moment to fill out the survey that we have and leave us your comment, all of your comments. Let us know what you thought of today's presentation. We are going to share your comments with our speaker. Also, I want to invite you to our next caregiver webinar, which will be on our understanding of chronic pain. And this will be hosted on May 17 from 12 to 1 p.m. We are going to have Dr. Daniel Claw, who serves as a director of the Chronic Pain and Fatigue Research Center at the University of Michigan School of Medicine. So I hope you can join us then. And I hope you have a wonderful afternoon, everyone. Thank you.
Bye-bye.
Bye.